Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Greetings, fellow legal minds. You may have noticed a change. We are now Just Verdicts. Formerly Trial and Medical Error, our podcast is undergoing a transformation. We're zeroing in on what truly matters: the strategies, stories, and mindset behind remarkable jury verdicts. Please join me as we dissect the anatomy of legal triumphs, spotlighting the lawyers, jurors, and narratives that shape courtroom outcomes. From pivotal cases to insider insights, we're here to fuel your passion for the law. So, to all trial lawyers seeking inspiration and knowledge, welcome to Just Verdicts, where every verdict holds the keys to success. In this episode, we're talking to Clancy Boylan again because he keeps hitting these big verdicts. And, Clancy, you have the, I don't know if it's an honor or a dubious distinction of being the first guest on my podcast that I've interviewed twice. So congratulations for whatever that's worth, man.
What do I win?
Well, to be determined. And yeah, unfortunately for you, about an hour of having me ask you boring questions. But no, man, it's great because it means you're kicking butt. I'm not surprised by it, given what we learned in the big trucking verdict you got. But yeah, man, congrats. You're really you're on a roll right now.
Appreciate it. Hope it continues.
Yeah, no, I'm sure it will. You're a young dude with the right mindset, it seems. So today we're going to talk about your verdict pretty recently in this Charles English and Elizabeth English versus the Fraley Schilling company. And then I'm guessing Chris Childs was the driver who you had to sue in the case as well, right?
Correct.
All right. So I just want to give a little teaser that I freaking loved the closing that you sent me. And as far as, I've read a ton of closing argument transcripts, and, when you do them, you feel like you're like a maestro and everything is perfect. You go back and read them and it looks like garbage. But dude, yours was so freaking perfect. Like every line, was just so well laid out. And I want to talk about, I love what you did with the structure of it and so forth. And there's just a ton of really good stuff in that closing that I want to touch on. But first, so we're oriented to what this case is about. Can you kind of tee it up? It's a trucking case, but give us the details about what happened and why and how did you wind up in court again?
Sure. So our client Charles English, he was also a truck driver. He's driving. It's like 9:00 at night. Bad weather, typical winter in northeastern PA. A ton of snow, and actually the I-81 was shut down for 3 days because of this storm. So our guy Chuck, he's been driving for a while. He knows in this type of weather, got to drive slow. So he cuts it down to about 20, 30 miles an hour, and he knows even in that speed, he could barely control his vehicle. Sees a accident up ahead, able to stop. He leaves a little bit of room in front of him just in case he gets hit from behind. And sure enough, that's what happened. The defendant came in, high rate of speed, hit another vehicle, bounced off the guardrail, and hit Chuck's vehicle. And Chuck had his foot fully on the gas, and the defendant was still able to push him about 150 feet.
So was this a 392-14 case?
Another one.
Which I know you love, right?
Oh, yeah.
So for those people on here, myself included, that are not, wizards of trucking litigation, can you talk to us about that regulation and why you like it and why it's so helpful to you in these cases?
Sure. So 392 in the FMCSR, what it says is that if any type of weather condition affects your visibility or your traction, you have to use extreme caution. And obviously the reason for that is safety. You got an 80,000-pound tractor trailer. If there's snow on the ground, ice on the ground, even when it's raining, if it's wet, the tractor trailer has a tougher time stopping. It takes it longer to stop, can't control as well. So the whole thing is cut your speed. And for a lot of tractor trailer drivers, they don't do it. They think they're, invincible, and they keep going. And sure enough, how many pileups do you see on the news in the winter on the turnpike or wherever where there's 50 cars because, a tractor trailer thought he can go 55 on snow. You just can't do it. And that's why I love them, because they just don't follow the rules, and the rules are pretty simple.
Why do you think that is? I mean, because I've heard a lot of times, is there an obligation for the trucking company to send out, an alert to the drivers that based on the weather, or is it more left up to the driver to make that decision based on the circumstances they encounter?
Yeah, it's based on discretion. And the great part about these cases, especially when we get in front of a jury, is juries are already afraid of tractor trailers. And then you start hitting them with, all right, now I got a guy going, 60 miles an hour, which under their own policies in this case was, they were supposed to go 30 miles an hour. You're going twice that speed in an 80,000-pound tractor trailer. And bad things happen. And it's easy for a jury to kind of get spooked about that.
So your guy is doing the right thing, following the rules, comes to a proper stop, leaves the room in case he gets hit from behind, gets smashed from behind by the defendant driver. What are his injuries? How do things unfold? Does he go right to the hospital and so forth?
Yeah, so it was actually caught. So we got it on dash cam from the defendant's video, which actually became an issue that we'll get into kind of, I guess, a little bit in trial. It became an issue of an adverse inference or a spoliation claim. Our guy had his dog with him. As soon as he stops, he looks in the back to check on his dog, gets back in, and he realizes, he sees the lights and knows, I got no chance here. So he grabs both hands on the steering wheel, takes a good impact. He feels immediate pain, kind of like in his left shoulder. Can't go to the hospital. He's got a dog with him, which was a I don't want to call it a vicious dog, but a dog that wasn't friendly to other human beings, so he can't go. So it takes him a couple days, and he gets back home, he sees the doctor, they do an MRI, and full tear right away. And they don't do the right one. The left one's bothering the most. He goes in about 2 months later, and they talk about surgery, and as we talking about that, he says, look, my right one really hurts too. The doctor says, look, can't do both at the same time because you need at least one arm. So we'll wait for that. So he has surgery, and that became an issue because it wasn't until like 4 months after the MRI, the right shoulder, same tear, almost the same tear as the left. Ends up getting surgery on the right shoulder. And then 2 years down the line, his trigger finger starts acting up, and he had to get a trigger finger release.
So did he have any pre-existing shoulder issues before this?
No.
Okay.
The only pre-existing issue that came out was when in regards to his finger, he had a comp claim back in 1992 for a cut finger. So defense counsel was trying to insinuate that he had pre-existing. And on redirect, I told my co-counsel, I said, get up there and say, hey, Chuck, is it true that when Bill Clinton was president, you cut your finger? And that jury got a kick out of that one.
Right. And what did it happen to be the same finger?
No.
Oh, so different finger that he cut it, and they're trying to relate it to this one. Oh, man. Yeah. Okay. That's a real stretch.
Yeah.
And then, pretty clean causation. Other than the fact he doesn't get treatment immediately, but clean causation because he's got no prior medical on the shoulders, and then it's a pretty consistent injury, but the guy, understandably puts both hands on that wheel, gets a giant, shot from behind. So that's pretty good causation then as far as, connecting the dots for damages. So
defense doctor gave us the left, challenged the right.
Okay. What was the right? Just degenerative changes and timing, big coincidence?
He just said it's such a painful injury that if he had it done during the crash, he would have felt it right away and would have complained about it.
So you alluded to this, adverse inference issue with the video, and in reading the closing, it seemed like you guys uncovered a ton of really, reckless conduct and very helpful evidence in support of your case. So can you walk us through kind of the discovery process, who headed it up, and, the type of witnesses that you guys focused on and some of the key evidence that you uncovered that obviously set up such a great verdict?
So this case was actually handled by Alex Heider in our office. He came into my office, I don't know, maybe about 2-3 months before the trial, probably 3 months. And gave me some lowdown about the driver and some of the infractions that he had. And I was like, I love this. We got a higher retention supervision claim. I was like, immediately file for punitive damages. He files, judge grants it that we could amend to add them. So now, like 3 weeks before trial, I tell his team, I said, just print me off every liability document. I don't need the medical records. Just give me every liability document. And I go through it. In this guide, the defendant, Childs, he worked for about 14 months. It was his first job as a tractor trailer driver at U.S. Express or Western Express, I'm forgetting now. He has 4 preventable incidents. They weren't technically DOT reportable accidents, but they were incidents. After 14 months, the company says, you're done. He's a safety risk. They fire him. 1 month later, Fraley and Schilling, who's got about 500-600 drivers, so this wasn't a mom and pop, hires him, doesn't give him any additional training, any additional supervision, and then within the first 14 months at Fraley and Schilling, he gets, I think it was like 3 hours of service violations internally caught. He blows a stop sign and causes a wreck. And he also, there was one other infraction there. That was his first 14 months on the job. They didn't fire him. He continues on. He ends up with, by the time of the crash, he had 7 hours of service violations, 2 stop sign violations, a crash, and 2 speeding violations, which led to our theme in the case, which we'll get into that, I guess, as well.
What did you have evidence that Fraley was aware of, via background or whatnot, of the infractions and why he had been terminated from the prior employer?
Yeah, they knew. I mean, they did do the background checks. They got the information. So our guy, actually, the defendant, lied on he put that he wasn't in any accidents. He put that he was never convicted of a felony, never had his license suspended. So it was like 4 or 5 times that he misrepresented on his application, and to Fraley and Schilling, it didn't matter. Oh, they also did, in October of 2018, the Smart Drive, it was like a quarterly review, and he scored 365 or something like that. The score that he needed to get was like 40. So he was way above it, and it showed instances of attaining extreme speed, just speeding in general, following too closely, like all this great stuff. So
I'm assuming that's one of those tests where you don't want the high score.
Yeah, you do not want the high score.
So yeah, I mean, you've got really, a lot of really strong evidence, and obviously jurors. Every time I do a focus group, whatever the case, I want to know, did this ever happen? Anything, before? Were there any prior instances? And here, you've got a clear pattern of kind of reckless conduct by this guy that then gets imputed onto Fraley pretty overtly. So talk about the video that you talked about before and the issues that came up at trial.
So the video that was passed to us didn't have a speed on it. And it had sound, no speed. We found out that the original video had the speed on it. And then Fraley and Schilling claimed that once they switched from Smart Drive to Samsara, they could no longer access the video with the speed on it, which the jury was like, come on, guys, like, in this day and age. So we got an adverse inference or split. I forget, we had to pick one or the other. I forget which one we picked, but we got that the reason that they didn't produce the video with the speed is because it would have been bad for him, which became an issue because they were challenging how fast he was going. We also got an adverse inference on their logs. They didn't have his logs for the day of the crash. Now, there were past instances for hours of service violations where they were excusing it, where they had his logs. But for the day of the crash, didn't have his logs. So, with a guy who had 7 hours of service violations, we were able to argue like, wow, this guy had a problem, and it's just so happened on the day of the crash.
Well, so help me understand, what's the implication then of like what might have the logs have shown that would have been further damning of them?
Sure. The logs could have shown that he was indeed over his hours of service. He can only drive, 11 hours, or he could have been driving more than 8 hours without a break. So that's where we got that issue.
And then as far as the evidence or testimony that you found out that the previous video of the crash from Fraley had shown the speed, first off, how did you find that out? Like, who testified to that? And then number two, did they testify as far as when they watched the original video, what the speed had said on the video?
So that came out in the course of just discovery depositions. And of course, nobody remembered what the speed was from when they originally watched it.
And nobody made a notation of it or any documentation about what the speed was on the actual video.
But lo and behold, 2 days after the crash, after they reviewed the video with the speed on it, they fired him, which ended up being one of the great questions of the trial, too.
And I think you alluded to that in closing, and we'll talk about that in just a minute. So tell me, you develop all this great evidence, and I was looking and sort of piecing together from your closing that your economics looked all total about $300,000, give or take. Is that about right?
Yeah, I think it was just shy of it.
Okay. Yeah, I saw like 42 past meds, about 79 past income loss, and then a future medical projection by one of my dear friends, Varsha Desai, of about $160K in the case. So, you've got pretty clear-cut damages, pretty substantial damages. You've got punitive damages in the case now because you guys quickly amended when you're looking at the facts that you've developed. You have a very strong case. Was there any claim of comparative in any way because your guy was stopped or anything like that?
So they were trying to say because he didn't put his four-ways on, but he had only been stopped for maybe 10 seconds. So they alluded to it, but then it never ended up on the verdict slip. So
no real strong comparative claim. And what I'm getting to is, was there an attempt to settle? Was there, substantial money on the table? Or, looking at the way that you talked about the case in your closing, it seemed that, they took a very hard line on liability for some reason.
Yeah. Just like we talked about the last time we were together, it's like every plaintiff's dream is on a clear-cut liability. They challenge it. They offered $750,000, and we're in Luzerne County. We weren't in Philadelphia, but I was riding high off my prior verdict, and I was a big swinging guy, and I told Hyder that he couldn't take it, and that led to a lot of uneasiness in my stomach when the jury went back, and I was waiting for the verdict because I didn't want to have pie in my face.
Well, but that's, I've been giving this a lot of thought lately in those type of situations. And, you can't, look into the crystal ball and tell your client definitively. And obviously, $750,000, for a 2-shoulder surgery case, that's a lot of money. It's, well more than double the medicals and stuff. I think the vast majority of attorneys out there take it, but you've got really, really strong facts in this case, substantial damages, and that they're not going to back down. They're not going to admit liability. So I give you a ton of credit. Obviously, it all ended wonderfully, and you look like a genius now. And you always take that risk that maybe you get a bad jury and you get less than what was being offered. But no, at the same time, that takes a lot of guts. And I think that's something that a lot of lawyers wrestle with about, well, what do I do in this situation? That's good money and so forth. And, what if we don't? But I think that you're there to try to maximize the outcome, which you certainly did in this case. So I can imagine the uneasiness, but I get it. You were feeling the momentum. You're on a hot streak, and you had really good facts. So you go to trial. Did the numbers change at all during the case?
They came to us and said that they could have got close to, I think, $1 million, and we just go away.
It's going so well at that point.
Yeah.
Okay.
Yeah.
So you get into trial. What was the jury selection like? As I've been talking with other people on this show, every county and every judge in Pennsylvania does it differently. So what was the jury selection process in your case?
We got to ask just a couple questions of the jury, and we kind of quickly honed in on, tort reform. And really our main question was, is there anyone here who believes that there should be caps on damages? Now, in Philadelphia, maybe we would get one hand raised. Well, we had a panel of 50, and I think 45 people raised their hand. So as everybody was coming back, we kind of got into it a little bit. And at the end of the day, like, we were worried about it, but we felt like we had a good panel. We had a teacher on there. We actually had a good mix of people. We had mostly older people, but we had some younger people. It was, it ended up being a great panel, but like when we first picked it, we're like, oh boy,
not sure.
It's on damages. Come on.
What was the actual process like? Was it a, discussion with a panel? Was it individual idea? Was it judge-led?
So the questions were asked, they raised their numbers, and then as we were bringing people back individually into the judge's chambers, we were able to ask some follow-up questions to a couple of the issues.
Were there any, characteristics or belief systems or answers that you guys were particularly looking for, either to deselect or, looking to keep on the jury?
There were a couple people who, as we kind of drilled in on the caps, I mean, we could tell, like, they were like, what we wanted was like, give us a number. If they gave us a number, it was a bad number, we were going to get them off the panel. But, I mean, for instance, though, there was one guy who said, I think the highest somebody should get is $500,000. And at first we're like, ah. And then, lo and behold, he goes, if somebody gets in a car wreck, they should only get $500,000 for their car. No more. We're like, okay, we'll take you on our panel. You're
right.
$500,000 for property damage. What are you going to give to somebody who's hurt?
Well, but that's really interesting though, because we always ask the caps question, but you guys were actually asking in follow-up, okay, you believe in caps, what's your number? And asking them to specify a number.
Yeah, that's what we were kind of drilling in. Like, they would talk a little bit and say, look, is there a number in your mind? Is there a number in your mind that you said, hey, no person should ever get more than this? And there were people who offered it, and we were able to kind of, just off of body language and listening to them, like, we knew on a shoulder tear, they weren't going to do well for us. They weren't going to get us over 750.
Yeah. And it sounds like you did not do this, but what are your thoughts in that scenario? Because I mean, this is kind of making the gears turn in my head here. What are your thoughts on, like, asking them, well, would 5 million be too much? Or suggesting a number at that point in time? Do you think you would have caught the wrath of the judge?
I think we actually did kind of do that. Not every single time, but we kind of threw out a number. I mean, we picked and choose when we did that. We didn't want to do it every time, but the judge was, surprisingly okay with it.
And defense counsel didn't freak out about it?
No.
Because, I mean, if you think about it, that's we're in Pennsylvania. We're one of 3, states or commonwealths, the entire country, where we can't suggest a number. And again, another awesome thing you did in your closing on how you addressed it, I thought was really great. And we'll get to that in a second. But, I think the sooner that you can get people thinking about what would be a fair number in your case, whether it, this is from an anchoring concept or whatever, I think the better. And I think that's really an interesting way to approach it, that if people are saying caps, the implication is that, they have a number in mind. So why couldn't you ask them, like, well, would this number under any circumstance be too high? And then you're kind of getting the double benefit of seeing how they react to that number, while also, potentially kind of getting them adjusted to the fact, well, maybe this case is about that if this person's asking about that number.
Yep.
That's interesting. I'm going to have to think about that. So, all right. So you get the jury, picked. You're relatively happy with them. But, you mentioned you're in Luzerne, which is not Philadelphia. I mean, is that a rural county, or is it something in between rural and big metropolis?
It's not rural. It's Wilkes-Barre is kind of like where the courthouse is. So we're 20 minutes south. It's where I'm from. 20 minutes south of Lackawanna. It was predominantly, like, always blue collar, probably 65% Dem, 35% Republican. And then once Trump entered the scene, it actually did this dramatic flip. And I think NBC News did a special on him, that it went from 65, 35 Dem, Republican and did a complete switch. And now it's like solidly Republican.
Okay. So you're in sort of Trump territory for the most part as far as things are concerned. Okay. Gotcha. All right. So you get jury impaneled. Who did you try the case with?
So I tried it with Alex Hyder and Brian Ruditis.
Was Alex who worked the case up for the most part, you said?
Correct, yeah.
And how did you guys divvy up, who did what and roles for the trial?
So Alex did opening, and then I handled all the liability. So I crossed the corporate designee, crossed the corporate designee twice because they called him in their case in chief. Crossed the defendant driver, crossed the accident recon, crossed their industry expert. Alex handled our treating surgeon, Varsha, and then crossed Dr. Banis. And then Brian did the wife, and Alex did the Mr. English. And
you would have done, obviously, liability in your case in chief for your own experts and support, right?
Yeah, I did our industry expert, yeah. And then I closed as well.
And how long was the trial?
So the trial lasted 4 days. We picked on Monday, picked and went on Monday, and then we got the verdict probably like 3:00 on Thursday afternoon.
Okay. So you guys ran a pretty tight ship because it sounds like there was a number of witnesses that you guys went through, right? Okay.
Yeah, Judge Gelb, she runs a very clean, efficient trial. Like you get there in the morning, you start, and you work to the end.
Anybody on video or live feed, or was everybody live?
So we had our doctor, our surgeon via video because he was in Ohio where Chuck lived. Our industry expert, Kirk Cummings, what's cool is Luzerne County allows you to do witnesses via Zoom live in the courtroom. So he was actually live, but he was appearing via Zoom, and it worked out really well. I liked it. Varsha came live, and actually all of their experts except for Dr. Banis were live.
Okay. Banis was recorded?
Yeah.
So let me go back to the, the Zoom live feed testimony because I interviewed these two great lawyers out here, Tom Crenny and James Tallman, and they got a really solid med mal verdict out in Fayette County, which is basically unheard of. They call it Fayette Nam for a reason. And they had their star medical liability expert beamed in, as they referred to it, but via Zoom, and they were going on and on about how effective it was. Like they were describing that the doctor was basically on this big giant screen, and they felt like it was tremendously compelling. And I think there's a lot of people out there that have never tried it or concerned about it, worry that it's like some version of like a pre-recorded video. But I mean, it seems like you liked it as well.
I thought it was awesome.
Well, what do you think? What about it? What works so well about it compared to the other mediums?
It's just look, watching video after video, juries can get bored, and even though it's like on this, they wheeled the screen, but you could tell like he's moving around, like he's with there, and saying, hey, can you say a few words? Test your microphone. So it was almost like, instead of sitting here in the witness stand, he's just right here on a screen. And it was effectively a live direct examination, and the jury was into it. So I wish we could do that more often because I thought it was effective.
And would you just pull up if you needed to show exhibits or pictures or anything like that? You could just pull up on the screen. They could see it. Everybody can see it, kind of thing.
Yeah, it's just like if we're doing a Zoom dep and you're pulling up a document, sharing your screen. And
no technical issues, really?
No, so our trial tech team was there and made sure there was like a hotspot and no issues whatsoever, no lag, no nothing. We got to sit at counsel table, ask the questions, and
yeah. I think that's something that I certainly myself will, I think, use more frequently now, having you being the second person that said it worked really well, and I think it's good for other people to consider, in their cases upcoming. Go through trial. So basically 3 days. I mean, pretty quick. I mean, you guys ran through. I mean, was that intentional or was it just the way that it went? I mean, you had everything lined up and you kept it quick and to the point.
Yeah, especially with our experts, we like to kind of move pretty quickly. We knew the corporate designee, when Alex told me about, he's a military guy, super likable. And I'm like, I don't care. Like, what I got on this guy, I'm going to put him on the roast and I'm just going to spin it. That went that was a decent amount of time. The defendant kind of gave me some pushback. That was a decent amount of time. But, their experts weren't that long, kept my crosses, except for Easter Day. He was their industry guy. He spoke. We had some pretty good interactions, but the recon went pretty smooth. So, like I said, we were started at 9 and we were finishing at 5. So you can get a lot done.
I've, heard a lot of people, I think Keith Mitnick at your firm has talked about this, and I've, heard it in, people within like the, Edge and formerly Reptile stuff talk about that, a lot of people think the case is basically over after opening statements. And curious, specific to this case, how you feel about that. So after openings, you guys had pretty clear-cut evidence. Do you think for the most part it was done at that point, and then it was just a matter of kind of, adding the piss-off factor? Or do you think you really needed all of the testimony to kind of fully get through to the panel?
Yeah, the week before trial, I said to Alex, I'm like, keep your opening short. Like 5 minutes or less. Don't allude to any of the specifics that this guy did wrong. We're just going to tell him that, then this became our theme, is that, he had a terrible record, and Fraley and Schilling had time after time to take him off the road. Essentially, he was a ticking time bomb waiting to explode. And unfortunately, on January 31st, he did, and then we played the video right at the end of closing. Right at the end of the opening, and then we sat down. But we didn't want to tip him off because we wanted to really generate that piss-off factor.
So you felt that kind of doling it out through the course of testimony was going to, make the point better than if you laid it all out or most of it out in opening?
Yeah, when I sent Alex my outline for the corporate designee cross, and we got to trial that Monday morning, and he looked at Brian Reditis and he said, "Brian, did you see Clancy's cross?" And he goes, "No, why?" He's like, "I looked at that," and he goes, "It was probably like 9 pages long." He goes, "There was maybe 2 questions that I could have asked."
That's awesome. So did he keep it like super short during opening?
Yeah, it delivered a stellar opening. I think it was maybe like 4.5 minutes long.
Wow. Yeah, that's got to be a record.
To the point. Yeah.
And did you use that theme that he was a ticking time bomb?
Yeah, my cross of Mr. Paz, basically I set up, would you agree with me that he had an absolutely terrible driving record while he was employed by you? No, I would disagree with that. I was like, well, were there people who had worse records than him at Fraley and Schilling? And he's like, well, and he kind of went on. But essentially what I said, I walked through each violation. And I started it by saying, can we agree that you had 12 red flags, 12 chances to fire Mr. Childs? And he said, no, sir, I don't agree with that. And then I went through the first one. When he got this hour of service violation, you could have fired him, could have suspended him, and I went through each and every single one. And finally, the last 2 violations before the crash, he gets 2 speeding violations. So we get to the last speeding violation, and I said, I could have fired him, right? No, I wasn't going to fire him. Could have suspended him, blah, blah, blah. I said, what happened next? He's like, I don't know. You got the outline. And then I was like, walked in the back to take a drink, and I would go, tick. I had to whisper to the tech guy, like, play the video, no sound. And I'm walking back to him, and I'm going, tick, 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 boom. And then the defense counsel stands up, and he's like, objection. Like, sir, you call me Clancy. Clancy, you need to ask a question.
That's great, dude. Did the judge admonish you at all, or you just kind of like leave it be?
She was like, come on.
How'd the jury react? You get any laughs?
They were dying laughing. But they portrayed themselves as this like super safe company, that they were industry leading, and like it's just, when you're in there, it's like knowing the record's better than them. And I knew they were going to do it. He took like 102 computer training modules. And so they were pointing to that when they brought him back up on direct in their case in chief. They're like, look, we do all this. Like, this is better than any other company out there. But I had gone through the records and noted that when he took these modules, he was spending like 2 minutes. So when I crossed him on it, I said, sir, 102. I was like, that's pretty impressive, right? He's like, yeah. I was like, industry leading? Yes, sir. I go, well, these look very important. So what do they spend, like an hour on each one of these? He's like, yeah. I was like, probably no less than 45 minutes. Like, no less than 45 minutes. And then I walked him through. I go, oh, well, here, rear end collisions. And then boom, show that he did 2 minutes. And the jury was just laughing. It's like, they can't help themselves.
That's amazing. So you showed, how long was the crash video? It was probably pretty short, right?
Yeah, it was like 20 seconds or so.
Did you have to okay that with defense counsel ahead of time or get court approval, or did you just show it and go for it?
They actually showed it in their opening, which is wild. And even they showed it in their closing. I had a couple of my buddies from home stop in to watch the closing, and they're like, and in Philly, I'm used to closing first and then do rebuttal. In Missouri County, you flip it. And they come out and like right in the first 2 minutes of their closing, they show the video. And my buddy's like, is he trying to do your closing for you?
Yeah, right. It wasn't very helpful to you guys. But maybe that was their attempt to try to, deal with the bad fact. But there's some that are so bad here. There's no dealing with them. You referenced this in the closing, and I wanted to point this out because I read, and I think that it's a very effective idea. So, that idea of questioning, was it their safety guy with you agree that there was 12 different times you could have fired this guy, 12 red flags, so to speak, right?
Yep.
So there's this psychological concept called counterfactual thinking that I was reading about. And it's basically like, this may have been before your time, but there was a movie called Final Destination, where death is trying to get these people that escape death. And the scene was, by a total fluke coincidence, this kid misses this airplane he's supposed to get on. And then, he's sitting there, and then the airplane takes off and blows up.
Yeah.
And the idea is that there's sort of like a power to the idea when people think of the alternate reality of what could have been. And the more times you can show that there was all these branches where this outcome could have been avoided, it could have been avoided here and here and here and here. I think it underscores the sort of inevitability, and to your point, the kind of ticking time bomb theme. And you mentioned it in your closing, and obviously you told me you did it now in the examination, and it strikes me as being very effective in making that point. Did you guys do any focus groups on this, or was it mostly just you felt like it was just so clear cut you had it?
Just went out and tried it. The whole ticking time bomb thing, I think what ended up really making it work too was he admitted every step of the way, no, should have been fired, should have been shot. And then they took the stance that this guy did everything right at the time of the crash. And so when he came back up, that's how I ended my second cross of him. I said, listen, and he referred to their drivers as family members. I was like, Mr. Childs, I'm walking by it. I got my hand on him, and he was cracking up laughing. He wanted to punch me in the face. I go, he's family to you? And he's like, yeah, he's family. All right, well, if he did nothing wrong in the prior 12 things, and then he did nothing wrong on the day of the crash, why'd you kick your family member to the curb 2 days later? And it was silence for 10 seconds. No idea what to say. And he was like, well, when we looked at the past record, I'm like, you mean the past record that you've already said you weren't going to fire him about? Well, you got to look at the, and then he just went on, and I could tell the jury. I was like, all right.
No good answer to that question. The jury
said that to us after. They're like, that whole, when he was there and you asked him that question, and he just froze. We're like, what is this company doing?
Yeah, those are powerful moments. And if you have that, ability, which clearly you did, to kind of let the moment sit there and just let them not answer, and there's that painful silence, it almost kind of tells everything there is. They literally have no answer, but they're going to come up with some BS right now anyway. I love it. So did you, and just out of curiosity, because there's something in your closing that made me laugh when I read it, in a good way. But when you questioned him, did you say, you kicked your family member to the curb?
Oh yeah. Oh yeah.
I think that's great. I know, but I think talking the way that you would, and everybody gets it, you know what I mean? Rather than being all, legal jargon or whatever, terminated your, whatever, I love it. And I think that, probably, again, when the case is going your direction, it's sometimes you can do no wrong, but I like the fact that it's just you kind of talking the way that you normally would to anybody during the course of the case. So let's pivot to the closing, because you're kind enough to share the transcript with me. And as I was saying, it was probably the cleanest presented closing I've read in quite some time. But I wanted to start first with, and I think this is always a great piece of advice to anybody, that sometimes you get to closing and it's like, oh my God, like, what do I do? It's got to become this amazing, what's my starting point and everything. And what you did as a general structure, which I think is like, you have to have a compelling reason not to do this, is you basically just structured it around the verdict slip.
Yeah.
And every piece of the summary of evidence, you would say, what's the first question? Here it is. So let's go through first questions are, were they negligent? Well, here's all the key evidence for it. And I'll just anecdotally say, in a case that my associate Mag and I got a good verdict in a few months ago, afterward, I did the same thing. Use the verdict slip. You have it right there. You're walking through. I'll even check the marks off of what I think they should check off. People came up after and said that was really effective to give us the guide of like what we should be thinking about of each question and where we should be going next and so forth. So, I don't know. I don't think you did that as much in the big trucking case as you did in this one. What was what was your difference? Was the other one just more hammering the punies, or what was it?
What it was, so we stayed at the Mohegan Sun Casino all week. So I basically ate Ruth Chris for like
every night.
And so we get done Wednesday night. We know, I got to cross the recon and then we're closing. And so we're sitting at the bar, having a drink, and Brian Verditis looks at me. He's like, "You all right?" I go, "I'm not." He's like, "What's wrong?" I was like, "I have so much, I don't want to curse, so much crap in my head." I was like, there were so many facts that came out, so much bad stuff. And I'm like, I have no frame right now. So I'm like, he's like, "Go back to the room." He's like, I'll pay for your drink. So I go back to the room and I'm sitting there. Now it's like 10 o'clock at night. And I called my friend Kelly, who's managing partner out in Nashville. And I was like, I need help to frame this. And she said, "You know what? Hang up the phone, text Keith Mitnick." So I text Keith, "Hey, can you help me out?" He calls me 15 seconds later. And God love him. He's the most amazing resource. He gave me one or two good lines, but he got fired up. He starts going, and it was like the direct opposite of what I needed. I need somebody that can. I don't. But there was two great lines that I love, and I used it. So then I hung up the phone, and I called Kelly back, and I was like, she's like, "Well, was that helpful?" I go, "Actually, it wasn't." I'm all over the place. But I'm like, these two lines I've definitely for you. So she we just talked it out, and it was just again, it was like the failure to accept responsibility and kind of hit that quickly and then just flow. And it just, for whatever reason, for me, it seemed that verdict slip, the way it was like, all right, just go through it. And I didn't want to hit, everybody knew every fact, every hour of service. I didn't want to bore them with that. I just wanted to kind of weave our theme in, hit the highlights and sit down, quite frankly.
Well, I think it's just a good, it's just a good takeaway, because, anybody that has, tried a case for a week or 2 weeks, and then it's time to that night before, or sometimes you have just a few hours to put the closing together, it can be overwhelming, because it's like you want to do, right by your client. You've invested so much into the case, and you want it to be this kind of tour de force for the jury, and you start to put too much pressure on yourself. Like, how am I going to convey this and communicate and marshal all the different things that happened during the case? But the reality is, I think that the jury gets it, and it's more of organization and hitting the key points, which is another thing I think you did really tremendously in that closing. That closing had to be 20 minutes maybe? It didn't seem like it was tremendously long.
Yeah, 20, 25 minutes, probably 20 minutes. I don't even think it was more than 20 minutes.
Yeah, just reading it, but it was kind of a good reminder to me, because, I nerd out, about all these different arguments I hear, and these different, I heard, Mitnick say this and Panish said that, and, Nick Rowley says to do this, and David Ball, and I've got 50 million different ideas. And sometimes I find myself just trying to crowbar all of them in, and it's just too much. You should be taking one or two of those key chunks, which you did, and putting them in there. And I think it's much more effective. And honestly, no matter how great the case is, no matter how, much, how awesome you think you are, honestly, I think the jury is just dude, we get it.
Yeah.
Hit a couple main points and be done already, so we can go do our job. So you lead with responsibility and accountability, that they just won't take accountability. And then you walk the jury through the verdict slip. Do you have the verdict slip in hand, or are you just sort of explaining it to them generally?
It was up on the big screen.
Okay, so you have it up. I think it's great. And then just using basically each question as your pivot point to kind of go through the key aspects that support why they should answer the way you're suggesting to them. So the one line that I just made me laugh when I was reading in your closing. So, we've talked earlier that this, really, just so underhanded, like, oh, the video changed and now we can't show the speed limit. And then here they bring in, some, expert to recalculate the speed. And of course, it's like he was driving under 35 or under 30 miles per hour. So but you go in your closing, how could he have stopped the amount of space he had if he pushed Chuck 150 feet? Mr. Dunn's calculations and his opinions, no offense to him, crap. I don't know. I don't know if you've even gone back and read it, but I was just reading that and it cracked me up. But hit the point that it's just completely ludicrous what they were trying to pull off here over this jury, and I just love stuff like that.
It's like serving up a meatball.
Yeah. Before we go on with some of the other things in your closing, I wanted to talk about what happened with the punitives. So I know that you were arguing for reckless. I guess ultimately, I didn't see the verdict. I saw what the number was, which was, what was it, 2.3 million?
2.58 and change.
Yeah. Sorry to undersell you there.
Every dollar economics, then they gave us 500 for loss consortium, 500 for past, 500 for future pain and suffering. And then we got a check mark for reckless on both the driver and the company.
And so is that a separate trial now?
So what they did is, now this trial happened in the week leading into Christmas.
Yeah.
And, they did not want to be there. And like when the judge said, all right, well, lucky for you guys, you still have one more thing to do. And I could see like the audible, like.
Yeah, no.
So, and by that time, I had nothing left in the tank. I had done like 6 cross-examinations. I just closed. And they put the corporate designee back on the stand, Mr. Potts, who I've already crossed twice.
This is after you got the verdict.
After we got the verdict. So they get testimony from him. And
wow.
When he testifies to, he's like, look, this is an employee-owned company. They went through all the charitable work that they do. It's like, we're like $800,000 in debt. I'm thinking to myself, there ain't no way they're going to tag these people with $1. Because they're not going to hit the driver, because they never do. So they get done, and Judge Gelb goes, all right, plaintiff, I'm sure you don't have any questions. And I was like, you know what, Judge, I do have one question. She's like, okay. And then I didn't even get up. Mr. Potts, will you now finally take responsibility for this crash? And again, 10-second pause. Doesn't say anything. Finally, defense counsel gets up. It's like, objection. Calls us up. She's like, what are you doing? I was like, Judge, I think that's the most fair question I've asked all trial.
Yeah.
Like, you can't do that. So sets us down. And
the judge said that was an improper question?
Yeah. But you know what?
What was the objection? Just out of curiosity, what was the objection? Like, what was the basis?
Honestly, I don't even remember what the basis was. They just thought it was improper. And, honestly, it didn't matter. I didn't need an answer.
Sure.
Because we sat there for 10 seconds with a blank stare. The answer was obvious. And I looked at the jury and said, I don't have any other questions. And they went back and they hit the driver for $300, which isn't coverable under insurance. And they hit the company for $500. So an extra $800 in punies.
Well, that's so interesting. So you didn't get any opportunity to go and do actual discovery of this company to find out their real financial position. They just had this guy testify under oath about, hey, this is where we are.
They gave us stuff. It was just like the last shot. Like, honestly, I just want them to kind of use their imagination. I don't want them to hear what the financials are. I mean, they gave the story about, we're all this and that. By that time, I'm like, look, we had just gotten $1.25 million or whatever, $6 million on 2 shoulder scopes. So I was like, it didn't matter if they didn't give them punities.
Yeah, but they did. They
did. Yeah.
Okay. And wait, so give me the breakdown again. So it was essentially they give you all the economics, which was like maybe a hair under 300, and then it was 500 loss consortium, and then what, $1 million total for him?
Yep, $1 million past and future, and then 800 in punies.
So I didn't see much in your closing about the consortium claim.
So interesting is we went into the trial thinking his wife was going to be the star witness, and that Chuck probably wasn't, he'd do okay, but like she was going to be the star. Chuck gets up there and he knocks it out of the park. His wife gets up there, and God love her, she was so emotional, and she was listening to them like basically blame them, and she gets choked up before she even gets on the stand. And I knew the story from talking to them as we sat each day for lunch, and what I thought one of the most powerful things was when he's out for basically 9 months, first surgery, second surgery, he can't use his arms, he can't do anything, he can't work, not bringing in money. His wife, who was taking care of her dad, who's 91 years old, she was spending like 12 hours a day, taking care of him. She went and picked up another shift, basically 6-7 days a week. So she was working 12 days with her dad, or 12 hours with her dad, 8 hours at the job, and sleeping like 4 hours. And it was rinse, repeat. And he's like, it made me feel like as less of a man as you can be, that I'm watching my wife just kill herself and I can't do anything about it. So that's kind of really the loss of consortium that I try to hit in my closing was like, look, he's watching her, she's picking up the slack, she's doing everything she can, she's grinding, and he hit a bad point. Like he got deep, dark depression, and then he overcame it, he got medication, and that kind of led into the English people, they're fighters. They weren't going to let this be the lowest point in their life. They fought and they got back to a place. And that's really all I had for loss of consortium. But apparently it worked for them.
Yeah, no, clearly. I mean, obviously, the husband talking about how bad it made him feel, what his wife was doing was that was the best evidence there was of what she was going through. And it was, sort of, it was honorable what she was doing. It wasn't like, oh, my wife was so miserable or anything. She's like, no, she just sucked it up and you said like she's working like 20 hours while he's sitting there on the sidelines feeling miserable that, less of a man, less of a breadwinner and so forth.
There was, real quick, there was one other great part. They played surveillance video, which we knew, we had watched it and there's nothing on it. He's just mowing his neighbor's lawn and that's it. But we knew 8 minutes into it, they started filming so this was their second marriage, but filming his stepdaughter, who was 20 years old at the time, and they film her and they follow her. So they asked to play the video, and I said, no objection, but you're playing the whole thing. And I can't believe they still played it, so they play it, and we're sitting there now, and it's 5 minutes in, 6 minutes in, and he finally, he knew the point was coming up. He's like, do we really have to play this whole thing? I was like, oh, you do. And then sure enough, 15 seconds later, you see this, and the jury gasped. They're like, holy shit, they're filming the daughter? And that was bad. And I hinted at it in the closing, but they focused a lot on their closing on that, thinking we were going to hammer that. I was like, jury already got that. I don't need to touch that. But that was a bad look for them.
And it looked creepy that they had some secret person creepy. Filming his kid now, not even him.
Yeah.
The gifts that you get sometimes at trial, right?
Yeah.
You hit in the closing, you make that point again, that counterfactual idea. They had 12 opportunities to do the right thing, to send Mr. Childs on his way before he hurt somebody. And they didn't even have to wait until number 12. I thought that was great.
Yeah.
And, what were before I get to the non-economic thing I thought was awesome, what were the two pieces that Mitnick gave you that you liked and used?
The one was enough is enough. It was just that line, it was so simple, and that's what Keith is great at. It's simplicity. And he just kept repeating that over, and he goes, you're in Trump country, that's going to be enough, draw the line, enough is enough. And I thought that was basically those two lines, I felt like I was able to kind of get behind those lines when I mentioned them. And I thought that was great.
I don't know if you meant to do this, but this seemed very, sort of old school reptilian theory to me that, you made the point that Chuck was in a big, giant 80,000 pound tractor trailer when he was hit from behind, but you made the point essentially that this could have been anybody. And then you took it to him. You said, had he and his wife been in their family sedan on January 31st, 21, they wouldn't be sitting it here. And the only person that would be here is their daughter because they'd be dead. And I thought that was a great point because you kind of just forget, oh, it's big truck on big truck. But it's like, that was just by fluke of coincidence, it was the big truck. It could have been anybody, and that starts making people think about themselves or loved ones and the real danger of this whole situation.
That is the only time that I referenced the video of the daughter, because I walked over to the table and that's what I said.
Oh, that's what that meant. I got you.
They're like, they're not sitting here. The one that's sitting here is their daughter who they filmed.
I didn't know. I didn't pick up on that, but now I get it. And then lastly, I just want to talk about, because I think you did this so well. So you get to damages, and you go through the economics, and then you pivot to non-economics, and you talk about that every time you try a case, you get two questions, and the main one being what the heck are non-economic damages? It's pain, suffering. And you lay that part out, and then you say the second question, because I love little things that you can use in, you can repurpose them, but you can use them in most cases. And I think this is so good for the Commonwealth of Pennsylvania, where we can't suggest a number. You go and you say, and the second question we always get asked is, how do we come up with that? Here's the thing. I can't give you a number. And I think we lose sight of the fact that we don't tell the jury that.
Yep.
And I think a lot of times jurors go back there and they're like, we didn't get any guidance. I mean, I've had so many cases where one of the questions was, how much are you asking for? How much is the plaintiff asking? You know what I mean? And it's like, we can't tell you. We can't tell you that. So what you do here is you tell them, we're not allowed to, but I can give you a tool to try to think about it and how you can. And so then you go, when we think about compensation, we think about jobs, whether you get paid hourly or you get paid by a salary. So that's how we think about compensation, jobs. And then you pivot into, essentially like kind of a job, like imagine that what happened to him was actually a job posting.
Yeah.
Okay. And I mean, walk me through. What's your thinking on how you use that, that non-economic damages piece in closing?
Somebody down in Florida, my buddy Grant, we were talking about that because we're always kicking around like, what do we do? Can't ask for a number. Like, all my coworkers down south get to do it. Like, they're asking for $15 million in a job today. I was like, God, I wish I could do that. But it just, for me, it felt like an effective way to flow from beginning to end to hit everything I want to hit in non-economic, because I get to hit that, like, the low parts of their life, how much this is affecting them, and then for the permanent injuries, like, it goes to death. And, it's not a job you could retire early from. This will be with you until the day that they bury you. And then it just gives you I feel like a good framework to hit the really good parts of your non-economics. And like, especially in this case, because we didn't really have a ton. I just had a few nuggets to work with, and it ended up working, but it flows then into the next part where we talk about this, like, kind of doom and despair, and it easily flows into powering the jury, where it's like, look, it's not all doom and gloom. It's like, you get to write the next chapter of this book, and they have the power, you have the power to, give justice, all that kind of stuff. So for me, I feel like, and I've used it now twice, jury that we hit in January, and I love it. It just feels right to me.
Yeah, I mean, I think it's very helpful because you're also dealing with, you go back to jury selection, you're dealing with people that said they've got issues with caps potentially, and I think one of the things behind that is that people have never taken the time to think about, why do we give money for pain and suffering?
Yeah.
And so you need to provide them, a tangible, concept and framework for, no, this is why we do it. I mean, Mitnick wrote in Deeper Cuts about, talking about, the civil justice system, like where it came from. We're going to be a civil system. It's not, we're not eye for an eye, but we don't turn a blind eye to justice and so forth. Yeah. And it's that concept of helping them understand that and then putting it in some type of a framework. And I actually think I've done a different one that I call the evil man that I've stolen from other people, but it's essentially the same thing. Like, somebody comes up to you and says, hey, I'm going to give you a whole bunch of money, but this horrible thing's going to happen to you. And at the end, like you did, and you point out and you say, now imagine that, that Chuck's given, like, that's the job. You think he's going to take that job? You know, no, he didn't have a choice. And that idea that he didn't have a choice in any of this different stuff, and then you're tying it to the compensation, the work component. And like you said, in your case, it works so well because here we are, trucker in the course and scope of a job, and again, he can't work and everything, really fit perfectly.
I like too, and then you get that really like the theatrical part where it's like, who in their right mind would take this job? Like, what would it have to pay? And then, nobody would take that job, but Chuck has to. And then you could raise it a level. It's like Chuck has to, and I walk over to that table and I said, Chuck has to take this. He's forced to take it because the actions of this table right here, and it just like gives you like a theatrical moment. Again, now you're hitting the damages, but you're refocusing on like, look, bad acts, piss off. Give me a big number. It's not economic.
Yeah, but I mean that's one of the main purposes of a closing is getting to that point where you're, connecting with them, you're motivating them, you're empowering them, and part of that is kind of, charging them up, exactly what you did there. And, that righteous indignation and that, add in that piss off factor because, again, especially I would wager in Trump country, people are not giving a verdict like this, because they want to help Chuck English. You know what I mean? I'm sure they felt empathy for him and maybe some sympathy and so forth, and they could resonate. But that's just more like, okay, like we can, we have a framework of how significant the damages were, but a verdict like this for 2 shoulder surgeries, this is because, you guys were able to get to trial and present this compelling story of people that are just not taking accountability. And a jury's going to get ticked off at that, and you guys did a masterful job at, helping this jury, see through the BS and wanting to truly hold them accountable. So I think that's awesome, man. So another one in the books for you, man, another bell ringer. I'm sure you've got a ton more coming down the pipe. Anything else about this that, you think is worth talking about?
I got one more. I alluded to in the beginning, we turned down all that money. And a bunch of my buddies from back home thought, you're crazy, man. You need a wheelbarrow to walk into that courtroom. And I felt like I did a great closing. Like I really felt it. But at the end of the day, I'm like, there ain't no way they're giving us more than $750,000. The jury goes back and I'm sick to my stomach. I can't eat. I'm sitting there, people are trying to talk to me. I'm like, no, doc, I'm done. Like I want to throw up right now. And then we finally get that call. We come back into the courtroom and I check yes. And like each time they say yes, the clients are sitting behind us and I can hear them like crying. I was like, I can't disappoint these people. Then they give us every economic. I was like, okay, all right. And then once they hit that 500 on the first number, I was
you're good.
I'm like, I'm over 750. And then they went another 500, another 500. And I normally try to play it cool, but I'm like elbow on hider. I'm just like, oh man.
Yeah, I can't play it cool. You start hearing that and it's hard not to have that emotional release on it and everything. I share your feeling, and I'm glad that you said that, you felt that nervously sick about the verdict because, I hate waiting on a verdict. But I think about, I interviewed Ryan McKean from up in Connecticut, and he and his partner got like $100 million verdict on this case against Phillips Lighting and everything. And they had, giant cojones to go to trial with the amount of money that was on there. But he was telling me that when they were waiting for the verdict, he was like, I was absolutely totally confident that it was gonna be a monster verdict. And I was just like, dude, I don't know. I don't care how good my case has gone in. I'm still like, waiting on that verdict. I'm just talking myself out of it. No, we're dead. We're probably gonna lose. And so I'm much more like you. I mean, I love Ryan's story, but I was like, oh my God, dude, I wish I had that kind of confidence in everything. But no, that's great, man. And congrats again. And, sharing all these materials with me and everything. If anybody wants to get a hold of you or, talk to you about trucking or refer your case or anything, where's the best way to people get a hold of you, Clancy?
Yeah, my cell phone's the easiest way, 570-262-0809. You can email me at cboylan@forthepeople.com. Got a couple more. I'm actually going to try a trucking case out in Missouri in April. So hopefully maybe I'll be back on here a third time.
Hey, good luck, man. No, you're absolutely welcome anytime. Getting a ton out of it. And is it cool if anybody asks me to check out your closing to share it with them?
Oh, absolutely.
Because I think people would love to read it. I think the format's awesome, and there's just a ton of awesome stuff you did in it that people would get a lot of benefit from. So thanks for sharing, man, and joining me back on the show. And, until next time after the Missouri case, be well, okay, man?
Sounds good. Thanks for having me.
All right, bud.
See ya.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.